May it please the court, my name is John Schaller, along with my co-counsel Daniel Sawyers. We represent Timothy Carpenter, the petitioner in today's case. Before the court, we have three issues: whether there was a Fourth Amendment event, whether the third-party doctrine should apply to cell-site location information, and whether 127 days was a long enough period of time to infringe on Carpenter's rights. Would the court benefit from a brief recitation of the facts?
Yes, thank you.
On April 2011, Carpenter was arrested in the Detroit area. He then confessed to more robberies in Michigan and Detroit. The FBI applied for cell site location information to be used for evidence. Carpenter moved to suppress this evidence before his trial, and his motion was denied. During his trial, several accomplices testified against Carpenter, and he was convicted on all Hobbs Act counts. He was sentenced to 1,395 to 1,428 months in prison. He now appeals his convictions here. I will be addressing the first issue, whether the use of cell site location information was a Fourth Amendment event. The use of cell site location information was a Fourth Amendment event and a violation of Carpenter's rights because no formal warrant was obtained to search the information. In Boyd v. United States, the court states that there need not be a physical invasion of one's home to constitute a violation of the Fourth Amendment protection against unreasonable search or seizure. The Fourth Amendment of the Constitution also protects against the invasion into a person's private matters. The cell site location information taken from Carpenter is a private matter and therefore should be protected because of this case.
But, Counselor, didn't the police have to go to a neutral magistrate under the Stored Communications Act and receive his blessing, very similar to the warrant requirement? How can we not say that having to go to that neutral magistrate, just like you would have to do to get a warrant, fulfills the warrant requirement under the Fourth Amendment?
Well, no, Your Honor, it shouldn't. Because if we allow this information to be used, that was when they gone to a magistrate judge, then other information could be obtained through the magistrate judge also. So this would create confusion throughout in the future.
Are there different standards for getting the order from the magistrate judge in this case than there are in getting a warrant from a neutral magistrate under the Fourth Amendment?
Well, Your Honor, I think both would need probable cause, but going through the process of obtaining a warrant would ensure due process for Carpenter. There's also no probable cause to obtain the cell site location information. If probable cause was present, a warrant could easily have been obtained to obtain this information for evidence. However, because no formal warrant was issued, Carpenter's rights were infringed when his location was revealed through the cell site location information that was used to incriminate him. We believe that our entire government needs to rethink the Fourth Amendment and its applications in our continuously growing technologically dependent society. The cell site location information was also obtained by unjust means of the Stored Communications Act. In order for certain information to fall under the Stored Communications Act, the court must have specific and articulable facts showing that there are reasonable grounds to believe that the contents of a wired electronic communication can be used in the investigation.
Now, Counselor, are you saying that the Stored Communications Act as a whole is unconstitutional, or just that its use in this particular instance was unwarranted?
The use in this particular instance. And the Stored Communications Act does not specify where the cell site location information may be obtained. Instead, it states that records and information sought may be obtained for evidence. This general wording makes it very easy for someone's right to be violated by this act, as it was in this case. This act gives much more power to law enforcement than is needed, and leaves a gargantuan amount of information that a person would want to remain private, vulnerable to unwarranted searches and seizures. By allowing this information to be used in court, the door has now been opened for an infinite amount of supposedly private information to be used against people and to be searched and seized without any warrants.
Counselor, how has modern technology impacted our view of what constitutes a search or seizure?
Well, Your Honor, on these cell phones that the majority of Americans carry, they store so much private information on them, and the Fourth Amendment needs to extend to these digital.
Now, in a previous precedent, we've said that GPS data, because it's so very exact, was a constitutional violation. Cell phone site location data is not as exact. Why should we hold it to the same standard as GPS data?
All right, it is less specific than GPS, but it's still specific enough to infringe on someone's privacy, so they would know where that person is and could draw a conclusion of where that person might specifically be. Validating the investigator's actions in obtaining this data through warrantless means by using this act as a substitute for a warrant is a clear violation of Carpenter's Fourth Amendment rights and his reasonable expectation of privacy.
The third-party doctrine cannot be applied to the cell site location information. Established in 1976, the third-party doctrine states that any information voluntarily handed over to third parties such as banks, phone companies, internet service providers, and email service do not have a reasonable expectation of privacy in this information given up.
Now, Counselor, since this was in 1976, did it include internet service providers in that definition, or has it just been expanded since then to include internet service providers?
No, Your Honor, it did not include internet service providers, we believe, and it has not been expanded.
Okay, so this court should not expand the third-party doctrine based on internet service providers. Those are substantially different than banks or other third parties that have been covered by this doctrine.
Yes, Your Honor.
How?
Further into my argument.
Okay.
Although this doctrine can be applied practically to certain cases, it cannot to this specific case and to cell site location information. In this age when technology is advancing at a far quicker speed than we could ever imagine, the doctrine that was established even before the first smartphone was invented cannot be used in any practical sense to call this to cell site location information that was obtained through a phone company. The New York Ratification Convention debates and proceedings states that every free man has the right to be secured from all unreasonable searches and seizures of his person, his papers, and his property. Cell site location information is considered property and is therefore protected because of Carpenter's rights as a free man.
Okay, but isn't it the phone company that is generating the cell site information location data? So wouldn't it therefore be the property of the phone company and not the property of Carpenter?
No, Your Honor, because he's paying for a specific service from that phone company and in turn getting that radio frequency that is transmitting that data.
Okay, so because he has a proprietary interest in the radio frequency transmitting the data, that also extends to a proprietary interest in any records that are developed as a result of that radio frequency.
Yes, Your Honor, because he paid for that specific service.
Okay.
Just because Carpenter's information was transmitted to a third-party cell phone company doesn't mean that he has no privacy interest in the said data. Carpenter would have a reasonable expectation of privacy in his property, and therefore the third-party doctrine is invalid in this case. Another discrepancy with the application of third-party in this case is that before the widespread use of cell phones, people could have the choice to filter information they choose to hand over to a third party. But in Carpenter's case, this function was automatic, and therefore not voluntary.
Well, couldn't he have turned off his phone and by doing so turned off the cell phone site location information data from being relayed?
Yes, Your Honor, but he was also using his phone at the time, therefore he couldn't turn it off.
Okay, does it matter in our analysis that cell phone site location data is recorded when I receive a call and not just when I make a call?
Yes, Your Honor.
How so?
Because whenever you receive a call, that information is still transmitted through that radio frequency that you paid for specifically. In order for the third-party doctrine to apply, the information given had to be voluntarily handed over by a willing and knowing person. Since Carpenter did none of this, it is clearly evident that the third-party doctrine holds no relevance in this case.
You're saying, Counselor, that voluntariness is an important bedrock of the third-party doctrine. When I enter into a cell phone contract, don't I relinquish any rights I have to the data that is generated as part of that cell phone service, and isn't that voluntariness?
No, Your Honor, we do not believe that is voluntary because you were not able to sign away your rights, Your Honor. And in this specific case, as I stated previously, every piece of information that goes through that radio frequency that is technically his property shall not be violated.
Carpenter also had his rights infringed when his records were obtained with cell site location information for 127 days. In the case of United States v. Jones, the court ruled that the placement of a tracking device to detect the location without a warrant over a 1-month period is unconstitutional. This case clearly mirrors that ruling. The cell site location information used to incriminate Carpenter is information taken from 127 days of tracking his location.
Yeah, but isn't there a difference between seeking the data from 127 days and tracking it for 127 days? They only asked for this information from the cell phone company one time. Yeah, it's information that covered a long period of time, but the Stored Communications Act allows them to go for up to 180 days. That's well within that. So how is this like an ongoing surveillance more than it is, oh, I just got this information one time, even though it covers a long period of time?
Well, Your Honor, we believe this is like that case because it was his location over time. We don't think that, like we said before, the third-party doctrine shouldn't be applied to self-site location information. So the 180 days would not have any relevance.
Okay.
Carpenter has a reasonable expectation of privacy in his location over a long period of time, and the period of 127 days is clearly long enough for someone to have their rights infringed. Because a reasonable expectation of privacy is established when Carpenter was tracked for 127 days, a warrant would be needed to search and seize the cell-site location information that was used in this case. When the location of Carpenter was revealed, his privacy was almost completely taken away. This is a clear violation of his right to privacy in his records that he has a reasonable expectation of privacy in. Using the privacy test established by Katz v. United States, it is again evident how egregiously the rights of Carpenter were violated. The Katz privacy test is used to determine if a person has a reasonable expectation of privacy. The two parts of the test are, does the individual have a subjective expectation of privacy, and is society prepared to recognize that this expectation is objectively reasonable? If the test is passed, then the person has a reasonable expectation of privacy. In this case, the use of cell-site location information should be put through this test. The cell-site location information used passes the first prong of the test. A normal person would be expecting to keep his location private and not have it used in a case against him. This expectation is subjective because a person would enjoy not having his privacy violated and having his location exposed at all times.
But when I go out in public, do I really have a subjective expectation that my location is a private matter?
Well, no, Harry, not at one point in time, but over a long period of time.
So it's the duration that gives him an expectation of privacy.
Yes, sir. With the cell-site location information also passes the second prong of this test. With the advancement of technology being faster than the laws that protect people's information, the public would be able to see this information as having an objectionable expectation of privacy. By passing the two-pronged Katz test, it is again evident how Carpenter has a reasonable expectation of privacy in the cell-site location information used in this case.
The data transmitted to Metro PCS and T-Mobile is still Timothy Carpenter's property. Since the data that was used to prosecute Carpenter came from Carpenter's phone and the components of the data itself come from the results of his actions, such as when he moves to another location, the raw data which they use as evidence is his intellectual property. This would result in the protection of the data due to the fact that the prosecution had no warrant pursuant to Carpenter and his cellular data. Carpenter paid for the cellular service, and therefore he paid for the designated radio frequency that depended on his cardinal directions in relation to the tower, and so the compounded cardinal directions that gave the prosecution his approximate location is his personal asset. In order to use this information as evidence, the prosecution would have to file for a search warrant in order to prosecute him with it. In other words, Carpenter owned the service, the data that he was getting and receiving. The contents of this data is effectively irrelevant in proving that he had no reasonable expectation of privacy because it was his property, which is protected under the Fourth Amendment.
And can he not give up any of that proprietary right through a contract with the phone company?
No, Your Honor, because it is technically still his property, and we believe that you may not sign away one of your rights.
Digital privacy needs to be protected by the Fourth Amendment. Private information that would be otherwise physically stored away pre-cell phone era is now carried within the cell phones that 95% of Americans have today. Information such as cell site location, personal health information, bank records, credit card information, and forms of personal identification are stored in many of these cell phones. Therefore, we find it essential, for the sake of everyone's privacy, that the Fourth Amendment needs to be able to expand upon this digital information, such as Carpenter's cell site location information, and needs to be able to protect this data. When the average American puts their information on their phone that they own, they should have a reasonable expectation of privacy, and as pursuant to the Fourth Amendment, have that right infringed upon only in the presence of a warrant that has been issued under probable cause. Due to how vulnerable cell phones make us, allowing the government to be easily obtain the data without a warrant would cause an immeasurable amount of distrust and cause people to resort to protected assets to communicate and store information on. As technology grows, so must our constitutional protection over them.
The use of cell site location information to incriminate Timothy Carpenter was an illegal search into his private life. This information was obtained through a warrantless search and seizure. The information cannot be seized under the Stored Communications Act. The third-party doctrine cannot be applied to the cell site location information seized by law enforcement. Carpenter also has his privacy rights infringed when he was tracked for 127 days, the unreasonable amount of time to observe someone's location. It is also clear that Carpenter had a reasonable expectation of privacy in this information when the CATS test is used. This case will be vital in the growing need for privacy while technology grows exponentially. Ruling against Carpenter will only lessen individuals' rights to privacy and the reasonable expectation of privacy. We pray that the Supreme Court will rule in favor of Timothy Carpenter because of the reasoning we have presented.